Your Excellency, Minister of Foreign Affairs of the Federal Republic of Germany, Your Excellencies, honorable judges, ladies and gentlemen, dear friends and colleagues. I am delighted and honored to speak to you on the occasion of the 2018 Nuremberg Forum, marking the 20th anniversary of the adoption of the Rome Statute. Allow me at the outset to thank His Excellency Minister Maas for his principled remarks in support of the International Criminal Court and international criminal justice, and similarly, our gracious hosts, the International Nuremberg Principles Academy, in particular my friend and former colleague, Dr. Klaus Ratzwig, for inviting me to this very impressive gathering. Physics teaches us that the forward thrust of an object, and the faster it moves through time and space, the greater the resistance it encounters. Whereas the adoption of the Rome Statute with the establishment of the ICC was in and of itself a new tidal force that changed the status quo of the world for the better, 2 decades after the Rome Conference, the system of international criminal justice created by the statute continues to make significant waves towards building a culture of accountability for atrocity crimes. The Rome Statute has set the course and the ICC is moving. It is moving ahead with dedication and determination. The support and encouragement of its many proponents and the plight of victims of atrocity crimes are the driving force which propel it forward. Whilst not bereft of challenges, we must acknowledge that its work in practice is increasingly shaping norms, casting a deterrent shadow across the globe. This forum offers yet another opportunity to not only pay homage to the Rome Statute, but reflect on our responsibilities, our methods and means at our disposals to ensure the enduring value of this important international legal instrument to humanity. I note in this regard the rich program and the topics selected for this forum, from case selection to victim participation and state engagement, and I very much look forward to benefit from the discussions to follow. On my part, it is my pleasure to provide, through this address, a reflection on the ICC's practice since the adoption of the Rome Statute, with an emphasis on the work and strategies of my office, the Office of the Prosecutor of the ICC, and while doing so, share with you a number of important challenges we face when conducting our core activities. I could not think of a more fitting venue for this occasion, so poignantly reminding us why we are here today. Indeed, reflecting on the events that led to the trials that took place in this very courtroom some 70 years ago, it was perhaps inevitable that the International Criminal Justice Project, with the ICC at its nucleus, should be a child of war. It was conceived in the wake of centuries of human suffering, with lawless violence and impunity wreaking havoc on the lives of countless victims. As we know, the critical mass pushing the balance towards accountability for atrocity crimes began to gain real momentum after the Second World War, on the heels of the experience of the military tribunals of Nuremberg and Tokyo and the international Nuremberg Principles. It was thanks to the efforts of countless dedicated individuals, and some present here today, from government, civil society, or other proponents of accountability for atrocity crimes, from all continents and different legal systems and cultures, that the ICC was made a reality in the Rome Conference in 1998. Since its operational start in 2003, the ICC Office of the Prosecutor has opened investigations in 11 situations, from the Democratic Republic of the Congo in 2004 to Burundi, most recently in 2017. The court's judges are yet to decide on our request to open investigation in Afghanistan, which I submitted last year around this time. Across our investigations and related prosecution of cases, we have achieved successes, but we've also faced setbacks. The past 15 years of operations have been informed by a multitude of factors. These have included the establishment of the office through its prosecutorial strategies and investigative and prosecutorial work, which has been tested and guided by the judges in the courtroom, thus giving concrete shape to the Rome Statute provisions in practice. Our defining factors have been the large-scale criminality followed by mass victimizations, coupled with insecurity on the ground, as well as the changing political climate in situation countries, but also in other countries and international or regional bodies supporting the court. Our resource capacity has also been far from ideal, and we have seen varying degrees of operational assistance, if not flat-out denial of cooperation by some states. Overall, the demands of the court's intervention and expectations for what it ought to deliver continue to increase. The latter becomes evident by merely looking at the hundreds of communications my office receives annually under Article 15 of the statute from states, international organizations, NGOs, or others bringing alleged criminality to our attention for assessment. Despite these challenges and realities, in the past 15 years, the office, as the engine of the court, has in many ways set the wheels of the Rome Statute, the court it created, and the international criminal justice system as a whole in motion. There are also no signs of slowing down these wheels in the future, as one can appreciate by looking at the office's ongoing preliminary examinations in situations spread across the world, from Nigeria and Palestine to Ukraine, Iraq, the Philippines, Venezuela, and most recently, concerning the deportation of the Rohingya into Bangladesh. Unfortunately, there are still too many situations in the world today where grave crimes appear to be committed outside the court's jurisdictional reach. Yemen, Syria, or South Sudan are just a few examples of conflicts that reminds us the importance of accountability for atrocity crimes and universality to ensure that all citizens may benefit from the protection offered by the Rome Statute. Ladies and gentlemen, when I assumed office as prosecutor in 2012, it was, in my assessment, a critical moment to engage in an honest and open look at the office's track record and to draw lessons from the early years of our operations. It is also my firm belief that, notwithstanding external challenges, my office and the ICC more broadly bear the first burden to build and strengthen the reputation and credibility of the ICC and the International Criminal Justice Project through performance and the effective exercise of the important mandate that we shoulder under the Rome Statute. That year and those following, we introduced significant changes to our prosecutorial strategy, presented through the first strategic plan of my term, with specific investigative and prosecutorial standards and policies as factors deemed critical for increased success. These changes were also designed to respond to the challenges of our operational environment. We also took a number of important concrete steps to ensure the office abides by the highest standards of professionalism as an investigating and prosecuting office with a critical mandate under the Rome Statute. As a key shift in focus, we started performing in-depth, open-ended quality investigations while maintaining focus. At the same time, working to be as trial-ready as possible from the earliest phases of proceedings, such as when seeking an arrest warrant and no later than the confirmation of charges proceedings. Also, where appropriate, we started implementing a building upward strategy by first investigating and prosecuting a limited number of mid-level perpetrators in order to ultimately have reasonable prospects of conviction for the most responsible. Additionally, in our investigations, in order to ensure the adequate gathering of reliable evidence, we have been undertaking efforts to reduce the time gap between events on the ground and the office's investigations by creating or strengthening existing partnerships with first responders in order to preserve the golden hour of evidence collection as much and as practically as possible. Simultaneously, we have been creating gateways for crime reporting, and we have been working with appropriate partners to preserve relevant information on the internet. In all this, it has been essential to increase our ability to collect different forms of evidence through continuous enhancement of our scientific and technology-related capabilities. While doing so, we critically look at and continuously review our investigative and prosecutorial standards. Likewise, process improvement projects, performance indicators, lessons learned, and development of new capabilities help to further shape the quality and consistency of the office's output. While it is difficult to predict outcomes in the courtroom, we treat each investigation and case with the utmost integrity, meticulousness, and dedication that they deserve. It is thanks to some of these strategic approaches that we are slowly starting to see results in practice. Of course, I hasten to add that we still face significant challenges, even major disappointments at times, but the trend, I am convinced, is a positive one. We certainly aim to set the bar higher and prepare for any obstacle as we head towards new challenges, with ever-intensifying activities, whether in number, complexity, or geographical scope. While noting that in the past years, the percentage of charges confirmed and the rate of convictions has already increased, ultimately, it is not the quantity, but the quality of investigations and prosecutions that we are constantly focusing on. Ladies and gentlemen, I would like to stress here that as my office undertakes its difficult but necessary work, it must be allowed a safe space to focus on its duties, free from unwarranted resistance and attempt at politicizing its legal work. Attacks on the court to undermine its important work, or in the service of Machiavellian schemes to shield the culpable, must continue to be met with the determined and unequivocal voices of support from principled states parties and civil society who stand by international criminal justice without reserve or distinction. While the notions and benefits of a multilateral rule-based order are increasingly devalued, we must be vigilant to ensure the achievements and progress of the past are not lost to these concerning trends. In this regard, I must say I was heartened by the very timely and vocal support from states parties and civil society during my most recent mission to the United Nations General Assembly, with positive references to the ICC as the centerpiece of the international criminal justice system and as a fundamental part of a rule-based order. Some 20 states stood up in partnership with the court and announced their support for the ICC during the general debate, while other declarations were jointly signed by countless other states parties, including by the host state of this forum, Germany, which I salute. Such vocal support is indeed crucial in times such as these, but equally important is tangible cooperation, especially when faced with pressure from actors who would like to see the court fail in delivering its critical mandate. This cooperation is key at the operational level, where my office will continue its work, undeterred and in conjunction with the myriad of other actors with whom we interact. The office and the court, by extension, cannot effectively execute our mandate under the Rome Statute alone. Closing the impunity gap can only succeed through a network of partnerships, promoting high-quality investigations and prosecutions at both the national and international levels in a complementary fashion. Eventually, the effectiveness of any such efforts will also depend on external factors, including the resources the court is provided to face increasing demands, and on the level of cooperation it receives for its core activities, in particular regarding the arrest and surrender of suspects. Investment in accountability for atrocity crimes and its deterrent dividends costs only a fraction of the vast expenditures and economic loss in times of war and conflict. There is also a great need for proactive efforts to ensure the arrest and surrender of the individuals for whom the ICC chambers have issued warrants. The continued presence and influence of the 15 suspects at large in the situations we investigate contributes to protracted tensions and violence. It is important for states parties to be more aware of the inefficiency unimplemented arrest warrants present to the whole Rome Statute system and take remedial responses by devising action, whether in the form of tracking and intelligence gathering, operational assistance, such as the provision of transport for suspects, or providing the diplomatic and political support to effect arrests and surrender. The office itself, in collaboration with the court's registry where appropriate, has been enhancing its efforts in this regard, from tracking to coordination and cooperation to increase prospects for arrests. And these efforts must be matched by states parties. This could include the provision of extra resources for investigative and analytical purposes geared to effecting arrest. In sum, the fact is that we rely by necessity and by the design of the Rome Statute system on the cooperation and assistance of states in a myriad of areas, from identifying the whereabouts of persons of interest to the protection of victims and witnesses. Tangible and swift cooperation would allow our investigations and cases to proceed more efficiently, and we hope to count on this crucial support and are committed to continuing to do our part. Ladies and gentlemen, I'll conclude by observing that as we commemorate the 20th anniversary of the Rome Statute in this historically significant courtroom in the life of international criminal justice, lest we forget that the creation of the ICC and its embodiment of the principle of the rule of law for accountability crimes was not merely an accident of history, but an absolute necessity based on the costly human experience of centuries of suffering from unchecked atrocities. As custodians of the Rome Statute and its values, states parties must, first and foremost, champion the goals of the Rome Statute, including its implementation in practice. This is the only way to ensure that the seeds of international criminal justice that were planted in this very courtroom will bear fruit as we work together to advance a more rule-based global order, where atrocities as merely politics by other means are no longer tolerated as an accepted norm. And it is a reality. There must be no going back in this forward march of humanity. I thank you for your attention, and I wish you fruitful deliberations.